I recorded an entire video and it did not keep my voice. So if I sound annoyed, it's because I am. Because I just recorded this 8-9 minute video and I have to redo it. And I swear to God, if it doesn't record my voice on this one, I'm going to lose it. So, as expected, the judge issued an order recapping what happened today at the post-discovery status conference. So, a post-discovery status conference is something that's been on calendar for a long time in this case. The parties knew about it in advance. It's something that gets scheduled early on, and so this is not a surprise hearing. The parties knew about it, and it's just a status conference. It's a chance for the parties to go before the judge and say, this is what's going on, these are the outlying issues, and raise any issues that they might have leading up to trial. Well, it looks like they had this conference. It involved both the Lively action and the Jones action, and the judge made some rulings about dates, one of which was not requested by the parties, which we'll talk about in a bit, but that actually impacts everyone here. Let's go through it together step by step. The first thing that the court says is that now that discovery is largely completed, parties in both of the cases are directed to contact the chambers of Magistrate Judge Cave for the purpose of exploring possible settlement. This line at the bottom of the page that says the court expresses no view with respect to settlement, that's for you guys, that's for the public. I have never seen a court actually express that, and that's because the parties all know that, the lawyers all know that, but this is to make it abundantly clear to the public that him directing the parties to go to a magistrate to discuss the possibility of settlement expresses no view from the court or from Judge Lyman about whether the parties should settle or not. It's just simply part of the process. It's just part of the checklist of things that courts go through to encourage parties to resolve their matters outside of court. Every single case I've ever had in federal and state court has had some form of alternative dispute resolution. And having the parties go to a magistrate, which is a judge with limited authority, limited power within the federal courts, is just one of the methods that the courts use to encourage parties to settle because trial is very burdensome, resource burdensome on courts. And so it is always the case that courts are trying to encourage the parties to settle. It does not mean that the court views the case in any particular way. And the court is saying as such in that line right there. Next, the parties are being directed to meet and confer regarding the anticipated motions for continued sealing, and to the extent possible to file a joint letter by December 19th, so 10 days from now, regarding documents and matters over which the parties agree sealing is appropriate. So what this means is that the court is aware that there's a lot of potential documents that need to be sealed, or there's a number of them, and has directed the parties to figure it out amongst themselves, to talk, to see, does this really need to be sealed? Are you going to challenge this sealing? Given how the protective order is laid out, directing the parties to seal confidential information, and given the fact that the court has already said that it is going to be inclined not to seal the majority of the documents in this case, he's asking the parties to do the work up front to figure out which ones really need to be sealed and which ones don't. So by December 19th, we will see a joint letter where the parties are going to lay out which ones they're okay with and which ones they disagree with. Instead of having the court go one by one through each and every single one, he wants them to come to some kind of agreement. And the parties are really going to have to take a really hard look at all of these because they are now preparing for trial. And so if there are documents there that they want to continue sealing, the question is, are you going to use it at trial? Because if you're going to use it at trial, then you can't really have it under seal. Relatedly, he tells the parties to follow the court's prior practice about what to do with audio or visual materials that are getting unsealed, like go give those CD to the clerk. Next, he addresses the fact that he would like to see oral argument regarding the Wayfarer party's dispositive motions, so the MJOP and the MSJ. And the third motion that he would like to hear oral arguments on is Lively's motion for spoliation sanctions. So of all the motions that have been filed, these are the three that he is most interested in hearing oral argument on. And how that works is that the court is going to take all the briefing, the final briefing of this, the dispositive motions will be filed on Friday, And I don't remember if the spoliation sanctions motions are fully briefed or not. I think there might be one more brief that will be filed. But once all the briefing is complete, the court is going to start digging through all of it and making decisions about things. And we'll come up with a list of questions, and we'll come up with a framework of how the court is going to rule. And then by January 22nd, supposedly, he will be ready to ask the parties specific questions about their arguments and allow the parties to share their arguments or make their case before the court with respect to those particular motions. So we will have a public hearing on January 22nd in the courtroom. It appears to be in person. Man, I really want to go to that. Should I go to that? I want to go to that. That will be the first time that we really see an indication of which way the judge is likely to rule. We won't know for sure because he's going to ask questions of both sides, but we will get some hint of how he's thinking and perceiving of the arguments in this case based off of the questions that he asks. So January 22nd is a really, really pivotal day for the case. We will learn a lot about the direction the court is going, and hopefully we'll be able to hear the arguments. Obviously, the big headline is that trial has been moved for 2 months to commence on May 18th. And some of those pre-trial conference deadlines and some of the deadlines that are triggered by the trial date have also been moved, and he's outlined those there. So the final pre-trial conference will happen on April 21st. That will be a chance for the parties to express any outstanding issues that need to be resolved before the parties can go to trial. And there will be motions in limine and proposed voir dire and jury instructions that will also need to be provided to the court before the trial commences. Those are all due on March 20th, with oppositions to those due on March 27th. So these are all deadlines that are triggered by the trial date that have now been moved as a result of the trial moving. The trial moving, as I said before in my last video, is very, very typical, and I'm surprised that it hasn't happened yet. I'm surprised that this is the first time it's happening. And so this is actually very normal for these deadlines to get pushed back. And like I said in the other video, I would not be surprised if it gets moved again. Although I do think that this judge really wants this case to stick to a deadline. But for the fact that he has to prioritize criminal trials, this trial has to be moved. Otherwise, he wouldn't have moved it. And last, he addresses the Jones actions and directs the parties to meet and confer and file a proposed schedule that the parties can agree on for the Jones motion to amend their complaint and motions for summary judgment. So there are a series of deadlines that have to be scheduled. And the parties are also directed to discuss a proposed schedule for Jones Works' motion for bifurcation in the lively action. Bifurcation is when you split issues off and you handle them in a different order, you handle them later. And so he's wanting that to be fully submitted shortly after oral argument in the lively action, which is happening in January. At this point, because I've recorded this a couple of times, I don't remember what I need to reiterate. But just to summarize, the court moving a trial date doesn't mean anything by the court. The court asking the parties to go to a magistrate to settle or discuss settlement doesn't mean anything. These are all very typical things that happen in a federal case, happen also in a state case. Nothing about this happening surprises me. If you start to read headlines about it, they're wrong, I can tell you, because this is just so typical. If you have questions still, drop them below and I will try to address them.